Hello, my name is Marcela Mattiuzzo, and I'd like to thank for the opportunity of being here presenting this very short research that I carried out regarding the Brazilian jurisdiction and preventive measures. So, first of all, what are preventive measures? Just so that we have the same vocabulary here. They're sometimes called injunctive reliefs and sometimes called interim measures. Each jurisdiction has its own name for them, but basically what they entail is a temporary decision that is taken before the final analysis of case, and that most of the time, the focus of that is halting behavior by a specific economic agent. So, why exactly are we using the case of Brazil here? So, obviously, for once, because I'm a specialist in Brazilian competition law, obviously, but more importantly, because Brazil is the jurisdiction that, unlike many others, has several cases that can be discussed, focused on such measures. Naturally, there are particular aspects of the Brazilian law that should be taken into account before we go into any more detail about the preventive measures themselves, to make sure we understand the background upon which these cases have been built over time. So very briefly, Brazilian antitrust law establishes a system that is basically administrative. That is to say that the Brazilian Antitrust Authority, which you all very well know, CADE, takes final decisions on matters. It approves or imposes remedies upon mergers. It also finds a company liable for anti-competitive conduct. In other words, in Brazil, we do not need to take a case to court in order to apply antitrust law to it. CADE can do that on its own, and it does that. Obviously, however, CADE's decisions can be challenged in court. That's to say that one can require that a judge analyzes CADE's decisions, and courts do have the power to revert those decisions. I'll not go into detail about how often this happens or how precisely it takes place, because that would fall outside the scope of our discussion. But what is important to know is that usually mergers are not questioned in courts, largely because Brazil has an ex ante system. But anti-competitive conduct, on the other hand, is much more frequently taken to courts. And as we shall see in more detail, any injunction granted by CADE can also be questioned before the judiciary. But what exactly can CADE do in terms of preventive measures? What does the law allow the authority to do? So the answer for that question is in Article 84 of the law, of the antitrust Brazilian law. CADE, be it at the general superintendency level or at the tribunal level, can grant a measure if two conditions are simultaneously met. So first, if there's sufficient initial evidence that the practice is causing competition harm to the market, which is what we usually call fumus boni iuris. You will, if you analyze by any chance a decision, you will often see that expression. Two, there's credible concern that this harm will lead to hardly repairable damage, or if it will render the final decision ineffective, which is what we usually refer to as periculum in mora. The article also establishes that, as a rule, the goal of the preventive measure should be to stop the practice and, when possible, to revert the situation to the previous status, what we also sometimes call status quo ante. So, other than that, there's also a provision at the Brazilian Code of Civil Procedure that regards provisional remedies. Why is that relevant? Because Article 84 of the antitrust law limits preventive measures to anti-competitive conduct analysis. So if CADE wants to use an injunctive relief, for instance, in a merger review proceeding, it must do so by way of the Civil Code of Procedure. So now that we have gone over this very brief overview of Brazilian law that applies to preventive measures, let's move on to the data. Ever since 2012, when the current law came into force, Brazil has had 19 cases of injunctions granted by CADE. Most of these cases are in conduct investigations, 15 of them, but there are also some cases focused on merger review. It's also worth noting that this number increased significantly over the past 5 years. Up until 2017, we had a total of 4 injunctions. 2 of them were preventive measures and 2 were reliefs. And from then on, we've had 15 new cases. It's also interesting, in my opinion, though it's not necessarily prescriptive, to highlight the cases in which those injunctions were granted. So digital markets do, to some extent, preponderate and represent 32% of the total. Though it's equally worth noting that we have quite a few markets outside of digital in which the measures were also granted, the most notable of which is sport services, which represents 24%. There's a particular reason for the port service case, which we will get to later on. It's also worth discussing the nature of the measures. So as mentioned, the basic aim of injunctive reliefs is to halt behavior. Because the behavior presents a credible threat that would be hard to reverse, it's halted even before a final analysis regarding the specific anti-competitiveness of the practice. But while in more straightforward investigations, it's easier to define what precisely should be halted. For instance, if you have a tying agreement, obvious decision would be to determine that the company no longer sells both products together and offers them separately. In more complex cases, the more complex analysis of what exactly the authority should do is also somewhat obvious, right? I'll use one investigation that is currently ongoing in Brazil that had a preventive measure to illustrate that point. So there was an investigation at CADE focused on analyzing the market for wellness platforms. Very shortly, what these players do is offer a platform for what we call wellness centers, dance studios, yoga centers, gyms, etc. And when an employer wants to offer a benefit in the form of a wellness card to its employees, instead of having to choose one specific gym to offer membership to, for example, it can offer a pass from these aggregators. The employee then chooses how to use the pass, and it will be accepted in several different locations. The dominant player in the Brazilian market today is Gympass. A competitor, TotalPass, filed a complaint before CADE saying that Gympass was signing several exclusivity agreements with wellness centers, and that for this reason, it was deterring entry and making it hard for competitors to, establish themselves in the market. It also argued that the exclusivity was sort of a naked restriction. It did not offer wellness centers anything real in return. It just impeded that center from being listed by another aggregator. The issue is here. Assuming that TotalPass was right, and I'm not going to go into detail on that, would it make a difference for CADE to determine that Gympass could no longer add exclusivity clauses in its future contracts? Would it be effective? If the market was already closed, would that have any impact? And if not, what would CADE have to do if it wanted to fix the problem? Determine that all contracts with exclusivity clauses be suspended, or that solely the exclusivity clause itself be suspended in the contract? Or would it have to analyze each individual contract and decide if that contract indeed had a naked exclusivity in it, and then suspend only the contracts in which that was true? So, in short, the issue here is that it's not really easy to determine what the injunction should provide for. And that runs from the fact that the market itself is not particularly simple. Jumping on to judicial review. I'll leave it open here for discussion whether the nature of the measures has anything to do with how the judiciary has been seeing these injunctions, but it's relevant to point out what happened in courts. As I mentioned earlier, administrative decisions in general can be debated in court, and courts have the power to maintain or reverse the decision taken by CADE. Since 2018, 7 of CADE's decisions on injunctions have been taken to the judiciary. In all of the cases, all of them, the judiciary sided with the companies and reversed CADE's measure. It's also worth noting that 4 out of these 7 cases focused on the same market and on the same kind of practice. These are the cases focused on port service I mentioned earlier. These cases all encompass the possibility of companies charging a fee for a specific service in the port market. The whole issue departs from a vertical relationship between port operators and companies that operate in port storage. CAGI understood repeatedly that some operators are also active in storage and use that vertical relationship to restrict competition. As you've seen, the judiciary disagreed. So what can we conclude from this very brief research and overview? I believe some takeaways are less controversial than others. I consider it uncontroversial to say that injunctions have been used more prominently in Brazil in the past years, for one. Also that to some extent, the nature of the decisions has to some extent, changed and became more complex. And also that digital markets have been a more prominent focus of injunctions. Though here I believe it's relevant to state that this could simply run from the fact that more digital market investigations have been assessed by CAGI, and not necessarily that digital markets are more prone to such measures. Finally, that the judiciary has been progressively less welcoming of CAGI's injunctive reliefs. I believe there's still a lot that can be discussed and assessed based on this research, but I do hope that it provides a first step for the analysis. Thank you very much.